Welcome back to The Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're talking about the bombshell ATF just dropped and how you can now legally shoulder an arm brace.
Sharps Brothers offers some of the most unique and well-built AR-15 and AR-10 receivers around, with models like the Warthog, the Jack, the Hellbreaker, or even the classic-looking Mean Streak. You'll be sure to find something to fit your build. To learn more about these and all of the other products that they make, head over to sharpsbros.com.
Don't forget, if you're attending the NRA annual meeting in Atlanta this week, be sure to attend the Gun Collective panel presented by NRA on Saturday, April 29th at 1 p.m. There's going to be all kinds of giveaways and your favorite content creators. To find out more, check out the link in the description. You may remember at SHOT Show 2015 when ATF shocked the gun community by releasing an open letter in relation to stabilizing braces, which proclaimed that if you shouldered an AR pistol with a brace attached, you had created an illegal short barrel rifle. For the analysis of what led up to this, be sure to check out the video we did on that topic called Can You Legally Shoulder SIG Arm Brace? I guess that's English or something.
English, do you speak it?
Well, thanks to the perseverance of SB Tactical, the creators of the SIG arm brace, it seems ATF has clarified the analytical framework it used to get from A to B, at least in relation to SB Tactical's products. ATF's new letter begins by describing the definition of a firearm under the National Firearms Act, or NFA, the definition of a rifle or shotgun, and that it has long held that a pistol with a barrel length of less than 16 inches and an attached shoulder stock is an NFA firearm pursuant to the plain language of the statute. ATF further states that, quote, because the stabilizing brace was not designed as a shoulder stock, use of the device as a shoulder stock would constitute a redesign of the firearm to which it was attached, resulting in the classification of the firearm as a short barrel rifle. SB Tactical pointed out to ATF that its analysis of the term use was untenable because the mere use of an otherwise lawfully possessed item for the purpose for which it was not designed does not constitute a redesign as defined in the NFA. The argument was supported by examples I've previously used in blog articles, such as the misuse of a screwdriver or a hammer, along with several other examples. ATF rejected what it described as, quote, the unstated but logical conclusion, end quote, of such an analysis because something was designed, intended, and marketed as a stabilizing brace, it could not be a shoulder stock. However, the ATF continues on. With respect to stabilizing braces, ATF concluded that attaching the brace to a handgun as a forearm brace does not make a short barrel rifle because in the configuration as submitted to and approved by the Firearms Technology Division, it is not intended to be and cannot comfortably be fired from the shoulder. You may remember from my blog articles that I've constantly raised the point that a redesign would require some affirmative step on the part of the individual. Simply shouldering a firearm equipped with a brace would not be enough, but rather somehow changing the brace or building a firearm with a brace with the intent to shoulder it from the beginning might put that firearm into the purview of the NFA. Apparently, not surprising, ATF agrees with me. The letter continues to explain that if the shooter/possessor takes affirmative steps to configure the device for use as a shoulder stock, for example, configuring the brace as to permanently affix it to the end of the buffer tube, removing the arm strap, or otherwise undermining its ability to be used as a brace, and in fact shoots the firearm from the shoulder using the accessory as a shoulder stock, that person has objectively redesigned the firearm for the purposes of the NFA. Remember all the hubbub about shouldering the SIG brace? It appears those days are over. ATF states that an NFA firearm has not necessarily been made when the device is not reconfigured for use as a shoulder stock, even if it happens to be fired from the shoulder. So what's the bottom line here? The part you guys are really going to like comes in this next paragraph. To the extent the January 2015 open letter implied or has been construed to hold that incidental, sporadic, or situational use of an arm brace equipped firearm from a firing position at or near the shoulder was sufficient to constitute a redesign, such interpretations are incorrect and not consistent with ATF's interpretation of the statute or manner in which it has historically been enforced. However, it is important to note that the brace must be in the original approved configuration. In simple terms, merely shouldering the brace, provided you did not modify it, does not constitute the manufacture of a short barrel rifle. Now you can all rejoice and buy all the arm braces you want without fear of being prosecuted for incidentally, sporadically, or situationally shouldering an arm brace equipped firearm, provided you didn't modify that brace. at least according to this letter.
What will you do without freedom?
Hopefully that gives you a better understanding of ATF's clarification to its interpretation. If you guys like this episode, you know what to do. Hit that like button and share it around with your friends. Have a question you want answered on the show? Head on over to the legal brief section on theguncollective.com. Do not forget to check out my website, adamkraut.com. And as always, don't forget to like The Gun Collective on Facebook, Instagram, YouTube, Full30, Snapchat, and wherever else you can catch us on social media. And of course, thanks for watching.
The shirts worn in today's episode of The Legal Brief have been provided by Patriot Patch. Click the link in the description to learn more.